Okay, seller, so this is a purchase agreement in California from the California Association of Realtors, and this is box G3. This is where the buyer and the buyer's agent have been asking for 2.5 or 3% buyer agent commission. And they've been doing that a lot because we know buyer agent commissions have gone up nationally in California. Let's say you're listed at 1.6, the offer comes in at 1.4, and you were to tell your seller, your listing agent, hey, I'd like to negotiate this because I want to put a little pressure on the buyer's agent. And if they're going to come in at 1.4 or 1.5, I don't want to pay more than 2% buyer agent commission. If I get 1.6, I'm happy to pay the 3%. Let's negotiate. Do you think your listing agent can do that? My answer to you is, not only can't they do it, they'd be practicing law without a license. And if they do it, and they do it without mitigating the risk, they're also heaping liability onto you or exposing you to liability for commission fixing, for steering, and for compromising the fiduciary duty of the buyer's agent. And all of it, I think, is quite obvious if you read what the class action suits were about and what the DOJ said. And just to make it clear, this is what a potential, let's say, this is what a counteroffer looks like. And so if you're going to deal with box G3, you could say box G3 is unchecked. Any request for compensation of buyer's broker must be made in a separate written agreement between buyer and seller and is not a term of the purchase agreement. And you could say, but seller is amenable to 3% as long as we get 1.6. Or however, there's myriad ways to do this. I personally would also, if I'm offering buyer agent commission of 2.5 or 3%, I'm going to make sure that the seller waives their rights to sue me. I'm going to make sure the seller understands that the money's coming from their funds. They need to acknowledge that because of the class action suits, in my opinion, as a lawyer. And I'm going to say, and therefore you could have requested a lower price, but you're asking us to pay your agent as a convenience to you. I mean, there's all sorts of mitigation measures. That would probably go a long way to mitigating some of the risk. There's ways to almost 100% mitigate all the risk if you want to do that. If you are not that risk averse, you might just negotiate it all in D. But it's very important for the seller to do this. And a listing agent, let's just review this. The California Association of Realtors removed all forms related to buyer agent compensation from the listing agent. It's been reported in the press because the DOJ told them they had to do that because they're not licensed to discuss it. In March, they had a circular that said sellers can pay buyer agent commission, but they should do so in concert with a real estate professional. And this was a circular that realtors be using. So of course it was, the professional was an attorney because there are risks involved, large risks. I don't think every seller should be paying buyer agent commission, certainly without being aware of the risks and how to mitigate them. But just in case anyone was saying, how could the realtors not be licensed to negotiate this? Let's remember, in the past, buyer agent commissions were the realtor's money. They would go to the listing agent and say, commissions are 6%. I'll be sharing my commissions with the buyer's agent if they bring a buyer and that buyer buys your property. If I bring the buyer, I'll get all 6%. And they might, and so sellers who were concerned about commissions might negotiate 4% with the listing agent. And then the listing agent could say, and I'll offer 2 to the buyer's agent then. So sellers who were concerned about commissions could pre-negotiate them with the listing agent. They can no longer do that. Listing agents are not allowed to do that. It caused $1.6 billion class action judgment against them. Listing agents aren't licensed to negotiate buyer agent compensation. Their forms have been removed, and there's nothing in their form packet that even has a seller authorizing the listing agent to negotiate buyer agent commission or get on the phone and talk about it. They're not licensed to do it. It's a third-party contract. Now, let me explain that they're not even licensed to decide what language to use in here or what method, whether they should keep it all in this or they should draft separate documents. They're not licensed to do any of that. And this is the Sipper case. This is a case that the Department of Real Estate cites in its flyer or circular on practicing law without a license. This is the foundational case. And it said, if a defendant had only, and this is the real estate agent is a defendant, if the defendant only been called upon to perform and had undertaken to perform the clerical service of filling in the blanks on a particular form in accordance with the information furnished by the parties. In other words, facts like address, price, closing date. If that's all they did, or they had merely acted as a scrivener, record the stated agreement of both parties to the transaction. If someone came to a realtor and they said, we've already worked on the deal, please put this in the blanks, he would not have been guilty of practicing law without a license. But the record supports, they go down here, the conclusion that he went further. He determined for the parties a kind of legal document they said execute in order to effectuate their process. So just picking the counteroffer document would be practicing law without a license. Certainly, writing information into the counter that would facilitate the wishes of the party without the party giving them the exact words, that would be practicing law without a license. And it's particularly heinous if they do nothing, because then the seller is agreeing right away to pay the full amount. They're not even negotiating. They're not even leveraging it. They're not even putting pressure on the buyer's agent to get this done quickly, closer to their terms. It's just accepted, and then all that's left is negotiation for the house or the closing date. So they're not making the buyer agent a little nervous and saying, hey, look, if you want to get paid, we got to get this done soon. If we're gonna go through 5 rounds and I'm going further away from my list price, or I'm not getting anywhere close to my list price, I'm gonna knock your commissions down. Well, if they've kind of given up on the first round, they're toast on that issue. So I just don't know how it's happening. So anyway, what is my solution? My point is, like many other states, if buyer agent commission is going to be paid, if it's going to be part of an RPA, like Carr could take this section out, and then I don't think buyer agent commissions would stay high, because the buyer's agents wouldn't have any ability to make the sellers pay for it unless they also hired an attorney. So Carr could take this clause out, and then maybe listing agents could sell homes without an attorney, unless buyer agent commissions were being asked, unless the buyers got their own attorney and drafted the proper clauses. But right now, as long as this clause is going to stay there, and I think it will, because what buyer would pay $30,000 on $1 million home to a buyer's agent? I'd say 1 in 10. Most of them be like, I'd rather have that money for a down payment or to get new floors or new appliances, and I'll pay you $5,000 or $10,000. I mean, the numbers I get paid when I help buyers buy direct from the listing agent as an attorney, who's also a broker, but as an attorney, and I review the contracts with them, and I do some other things. I review disclosures and repairs with them, but they pay me. It's rarely $10,000, but they are willing to pay to be protected sometimes, but not $30,000. That would be rare. So the Sipper case tells us that a listing agent cannot respond to a counter properly. California tells us that they've removed all the forms. The counter is an opportunity to get a higher net, a higher selling price, and mitigate your risk. And the answer is, the answer is that I believe attorneys who refer their clients to listing agents should now be getting paid, $6,000 to $10,000 minimum amount of work is being done by the attorney on the file, between reviewing disclosures, between reviewing the purchase contract, between helping select the counter language and the mitigation, and crafting the mitigation to the seller's desires based on the offer and what the market's doing at the time. If you're paying full commissions and the market's weak, maybe you don't make the buyer jump through a lot of hoops. But if you've got a different kind of market, a strong market, or you're willing to pay 3% buyer agent commission or the full amount requested, educate the buyer, make them jump through the hoops, and mitigate your risk significantly. Why not? So these are things an attorney would do in concert with a seller. So I'm putting together, I've already put together this whole program, but I'm putting together a free video series on each of these sections. However, this is really for your information. This is to prove my points. This is to explain the risks. What steering is, what commission fixing was happening in the class action suits. How do you compromise the fiduciary duty of the buyer's agent? How would you mitigate against it? And the risks brought about by offering inconsistent levels of compensation instead of broadcasting it. Although broadcasting, if you're not mitigating the risk, would also probably create risk. So, sellers need to decide, do you want to sell homes the way realtors used to and get multiple offers and leverage buyer agent compensation, probably even better than when they could put it on the MLS? Do you want to do that to get multiple offers? It's okay if you're mitigating the risks. In fact, I suggest it. I did it. That's part of my 7-day max price. When you're doing something very transparent with respect to buyer agent commission, having the buyers compete against each other, including the buyer agent commissions, you can do quite well. But you have to have someone who can get on the phone and talk about it with the buyer's agents. Someone who's licensed to do it and has a written authorization from you to do it. So all this is part of the program. I'm going to have free video series that's available for free at listingattorney.com let's say I believe it's listingattorney.com/video. There'll be the free video series. I have this seller starting with zero. This is a very important start. I have that form in there available for free, and I'm going to cover the 4 risks. In fact, I already have. It's a long video. I might break it up into shorter ones. It's a 10-minute video. And then, this is what a seller would need to know to be aware so they can make choices that it's fair to them. This is what a listing agent needs to understand and consider. Are they going to be able to represent the seller well during what I consider the best way to get max price and max net with max protection? And then can they fall back on a regular realtor methods? This is what an attorney can do. An attorney who already stands what I'm talking about doesn't really need to work with me. An attorney who wants to get paid more and has clients they refer to clients, I've got a program. We can work together. I even have training if you'd like training. This module, this is where these 2 modules are where all the magic happens for sellers. This is protection. This is max net, max price, max protection, and this is actually how you do it. My name is John McConnin. This is at listingattorney.com. And right now I'm focusing on attorneys who refer clients to sellers. But, if you're a seller and you want to be referred to an agent who can actually protect you, like, you talk about concierge seller. How about a listing agent who cares enough about you that they protect you and their franchise from lawsuits by mitigating the risks? I mean, wouldn't that be just part of being the best listing agent? One who actually is concerned about your future so you can sleep at night. So, I say find the best realtors in your area who have experience selling your homes, but bring an attorney in, maybe us, who can protect you and show your agent how to protect you well and still sell for max price. And realtors, I haven't figured out what the program is yet for you all, but if you're willing to put an attorney on your team, go to the website and let's talk, and I'll help you protect your sellers, sell for max dollar. And I understand, I need to find a way to reward you guys for being so concerned about your clients. Haven't figured it out yet, but I'm willing to talk to you. My name's John McConnin. I'm a broker and attorney in California. And this is the first video. Well, it's not really the first, but it's the beginning of this comprehensive series that I put together. Thanks. Bye.